Danielle Conway, and I am the proud Dean of the University of Maine School of Law. Today I have the great honor to introduce you to Constitution Day. Constitution Day is celebrated around the nation. Here today, we are celebrating it with a wonderful speaker that you will hear about from Harvard Law School. But I want to share with you not the obligation of Constitution Day for entities that receive federal funds. What I want to share with you as I introduce this Constitution Day is the very real fact that my presence here as your dean is the benefit of a reimagined Constitution. I am an African woman in the state of Maine. I am the spouse of an immigrant, naturalized under our United States Constitution. Without this Constitution and its commensurate rule of law, I would not be here. So it is not an obligation to celebrate Constitution Day. It is a commemoration that a collective group of Americans thought it important enough to include people like me. That is my Constitution Day. And I am very pleased to turn the microphone over to former Associate Dean for Academic Affairs and Professor of Law, Jennifer Riggins, who I know feels the same way I do.
Thank you, Dean Conway. It is a joy and an honor to introduce Joe Singer, the Bussey Professor of Law at Harvard Law School. Joe is a prolific, nationally known legal scholar whose work is creative, groundbreaking, and influential in a whole range of areas, including property law, conflicts of law, philosophy, and the law pertaining to Indian tribes. He has written over 80 law review articles, 3 books, a property case book, a treatise, and is one of the executive editors of Felix Cohen's Handbook of Federal Indian Law, which is the leading casebook treatise on federal Indian law. A recent article is The Indian States of America, Parallel Universes and Overlapping Sovereignty. He is an outstanding teacher also, whose long-standing focus on pedagogy and students matches his scholarly achievements. He is a legal titan in legal education. We're very, very lucky to have him here. He clerked for Justice Morris Pashman of the Supreme Court of New Jersey after graduating from Harvard Law School. He got his undergraduate degree at Williams College and a master's in political science from Harvard. He practiced law and taught at Boston University School of Law before joining the Harvard faculty. And incredibly enough, he is also an accomplished violinist. He really typifies what a lot of us at Maine Law feel about being an engaged scholar and teacher. So we're delighted to welcome him here to give the 2017 University of Maine School of Law Constitution Day lecture. Thank you.
Good afternoon, and thank you, Dean Conway and Professor Riggins. 5 days after taking office, President Trump canceled President Obama's order to prepare an environmental impact statement for the Dakota Access Pipeline. It was his first official action as president concerning Indian affairs. He did this without consulting the Standing Rock Sioux Tribe or the Cheyenne River Sioux Tribe. 5 months later, oil began to flow through the pipeline. It went through unceded lands guaranteed to Standing Rock Sioux by the Fort Laramie Treaties of 1851 and 1868. The 1868 treaty is still fully in effect, and it preserves tribal property rights in the adjacent Missouri River. Any pollution of that river would violate the property rights of the Standing Rock Sioux and the treaty commitments of the United States. President Trump was not concerned about the possibility that the pipeline might harm the tribe's property and treaty rights. Nor did it matter to him that the residents of Bismarck, North Dakota, had lobbied to protect themselves from the very thing the Sioux are now worried about. When oil began to flow, President Trump was overjoyed. The Dakota Access Pipeline is now officially open for business, he said. It's up, it's running, it's beautiful, it's great. Everybody's happy. The sun is shining, the water's clean. When I approved it, I thought I'd take a lot of heat, but I took none, actually none. That is a puzzling statement. David Archambault, the chairman of the Standing Rock Sioux Tribe, had a lot to say about Trump's pipeline approval. Chairman Archambault said, just because oil is flowing today doesn't mean it won't leak in the future. There's an uneasy feeling that at any moment this pipeline could pose a threat to our way of life. The concerns are not irrational. The pipeline has already leaked several times. If it leaks in the river, the chairman tells us it threatens the Sioux way of life. The 1868 treaty promised the tribe that their current lands were, quote, set apart for their absolute and undisturbed use and occupation, unquote. Pollution of the waters of the Missouri River bordering the Standing Rock Sioux Reservation would infringe on the tribe's property rights and would also violate the treaty commitments of the United States. However, the pipeline has not yet leaked in the river, and it may never do so. Does the mere threat of pollution violate the treaty? The answer to that question depends on federal law governing treaty interpretation. The Supreme Court has held that treaties with Indian nations must be interpreted as the Indians themselves would have understood them, and that any ambiguities must be interpreted liberally to preserve tribal sovereignty and property rights. The land promised of the Standing Rock Sioux is not fungible with other land. They cannot simply move somewhere else. They are, in their minds, where God meant them to be. Chairman Archambault has explained that the tribe's way of life is threatened by the pipeline. If we interpret the treaty the way the Standing Rock Sioux would have interpreted it in 1868, it is almost certainly true that the United States has already violated its promise to set aside the reservation for the undisturbed use of the tribe. Why does it matter that the United States may be, even now, violating its promises to the Standing Rock Sioux tribe? It matters because the Constitution of the United States makes treaties the supreme law of the land. It matters because in our constitutional system we believe in the rule of law. It matters because we believe in democracy. But it is apparent that President Trump was not interested in learning about the Fort Laramie treaties. He was not curious about how the tribe interpreted the rights they secured in those treaties in exchange for giving up most of their territory to the United States. There's a moral to the story, and it is not simply a complaint about President Trump. The president's failure to consult the Standing Rock Sioux tribe or to consider whether the pipeline violates treaty rights is a symptom of a larger problem. Yesterday was Constitution Day. I'm here to talk about Indian nations and the Constitution. Most Americans, and it's not just Trump, most Americans are insufficiently knowledgeable about Indian nations and their status in our constitutional system. The fact that treaty rights might be relevant to pipeline placement is not well known by non-Indians. The fact that Indian nations have constitutionally protected rights promised to them by the United States in treaties is also not something generally taught in elementary school, nor is it something that is generally taught in most law schools. Unless you take a specialized course in federal Indian law students are unlikely to hear about tribal treaty rights. If that is so, then they are likely to ignore the fact that it may be unconstitutional for the United States to violate those treaty rights, at least until Congress repudiates the obligations of the U.S. by repealing those treaties. The United States occupied Indian lands and passed laws limiting the powers of tribal governments. Yet the United States has not abolished tribal governments, nor has it erased Indian nations from the map. You would never know that if you look at traditional maps of the United States. Those maps, at least the ones I grew up with, and many maps today, show state borders, but generally do not show Indian country, the areas that remain under tribal control. Some maps have started showing those areas. You can see the borders of the Standing Rock Sioux Reservation, for example, on Google Maps on the computer. Our maps, our political discourse, and our law schools should not erase Indian nations. Indian nations matter because they had sovereignty before the colonizers came. They matter because their sovereignty persisted after the United States was formed. Conquest happened, but it was incomplete. Contrary to the assumptions or beliefs of many Americans, tribal sovereignty never went away. Indian nations not only have sovereignty, but they have a government-to-government relationship with the United States. The United States is a nation of 50 states, but it is also a nation of nations. 567 of them at last count. The U.S. Constitution established the United States, but that act did not and could not by itself disestablish the Indian nations. The Constitution is based on the notion of we the people, the government of the people, by the people, and for the people. The Indian nations did not sign the Constitution. How did they ever come under U.S. sovereignty? If democracy and self-determination are the normative basis of our constitutional system, then the only way they could legitimately become part of the federal system is through treaties. That means, as the late Professor Philip Fricke explained, that treaties are quasi-constitutional documents. They define some of the contours of a legitimate relationship between the Indian nations and the United States. And they limit the legitimate powers of the United States in Indian country. That means that the U.S. cannot live up to its own democratic and constitutional values if it does not respect tribal sovereignty. We cannot comply with those constitutional values if the United States refuses to consult with Indian nations about federal laws and actions that affect reserved tribal rights and interests. As the Dakota Access Pipeline teaches us, we cannot do that if neither lawmakers nor the general public are aware that Indian nations are sovereigns, recognized and protected by federal law, and that they always have been. Does the Constitution have anything explicit to say about tribal sovereignty? The answer is quite a lot. The Constitution both protects and undermines tribal sovereignty and property rights. The relation between tribal governments and the United States is complex and ever-changing. The Constitution recognizes tribal sovereignty and classifies tribes as nations. On the other hand, the Supreme Court, many presidents, and Congress have interpreted the Constitution from time to time to allow conquest. The result of this good news, bad news situation is that conquest happened, but again, it was not complete. We live in the United States, but we Americans share this land with Indian nations. In a very real sense, we, all of us, live in Indian country. In that vein, I wish now to acknowledge that we're on land originally occupied by the native inhabitants of the state. The fact that title of these lands has been transferred under federal and colonial law does not alter the historical connection between the land and the native nations who lived and continue to live here. I wish to convey my thanks and my greetings to the four federally recognized Indian nations in Maine. The Aroostook Band of Micmacs, the Holton Band of Maliseet Indians, the Passamaquoddy Tribe of Maine, and Penobscot Indian Nation. I recognize also there are nations here not recognized by the United States. That lack of recognition does not mean that they do not exist. There are two things every American should know about Indian nations in the Constitution. First is the good news. Compared to other constitutions around the world, our Constitution is remarkably protective of the sovereignty of Indian nations. In some ways, our Constitution has created a system that is more protective of tribal sovereignty than any other nation in the world. Second, the bad news. Our Constitution has been interpreted over time in ways that betray its most fundamental democratic values. The Supreme Court has allowed the U.S. government to deny basic constitutional rights to Indians that it confers on non-Indians. It has interpreted the Constitution to enable the United States to engage in conquest. The Supreme Court has itself engaged in acts of conquest by limiting tribal sovereignty without any legislative or constitutional authority to do so. Americans need to know both the good and the bad. We must be aware of the ways the law unjustly oppresses Indians and Indian nations, but we must be equally aware of the ways the law protects and affirms their equal worth and dignity. Let me start with the ways the Constitution protects Indian nations. The Constitution starts with the words, "We, the people of the United States of America." Were Indians part of that people? The answer is no. The Constitution was ratified by the 13 states, not the Indian nations. By adopting the Constitution, the United States could not and did not become sovereign over Indian country. That is in accord with our democratic values. What does the Constitution say about Indian nations? It mentions Indians 3 times. The Constitution gives Congress the power to regulate commerce with the Indian tribes. Notice that this Indian Commerce Clause does not give Congress the power to regulate Indians or Indian nations, just commerce with them. The Constitution twice excludes Indians not taxed from the population count for the House of Representatives. That has been interpreted to mean that Indians residing in Indian country were not state citizens because they were citizens of their own nations. Finally, the President, with the advice and consent of the Senate, has the power to make treaties with other nations, and from the very beginning of the Republic has done so with Indian nations. All this means is that the Constitution explicitly recognizes Indian nations as nations whose sovereignty is separate from that of the United States and the several states, and whose sovereignty persists despite the adoption of the Constitution. The text of the Constitution does not grant the United States sovereignty over Indian nations. The only way they became legally associated with the United States was the treaty process. And treaties, by their very nature, are between sovereigns. Between 1778, when the first treaty was made between the United States and the Delaware tribe, and 1871, when treaty making ended, the Senate ratified about 370 treaties with Indian nations. Again, because we are a democracy and we base the Constitution on the consent of the governed, treaties are the only potentially legitimate democratic source of federal power over Indian nations. While many of the treaties were the results of coercion, they at least recognized tribal sovereignty, and some retained property rights. The least the United States can do is to honor the promises it actually made to Indian nations. After all, the Indian nations paid an awful lot for those promises. Because treaties are the supreme law of the land, the United States, and that includes the Congress, the President, and the Supreme Court, are constitutionally bound by those treaties until they are repudiated. Chief Justice John Marshall interpreted the relationship between the United States and Indian nations in the 1823 case of Johnson versus McIntosh. That case is often taught in property law courses, and just as often misunderstood. What it actually holds, I believe, is that the United States asserted sovereignty over Indian nations only to the extent that it would not tolerate their allying with another nation, such as Great Britain or France. The case also held that Indian nations cannot transfer fee simple title to land to non-Indians without the consent of the United States, although they are perfectly free to grant property rights to non-Indians under tribal law. Beyond that, Marshall held that the United States could acquire tribal lands only with the free and voluntary consent of the tribes. His opinion contains a great deal of highly offensive racist language, and it forthrightly acknowledges that the Supreme Court cannot protect the Indian nations from past acts of conquest. At the same time, the Johnson opinion actually puts a brake on future conquest, or at least tried to do so. No more seizure of tribal lands without consent of the tribes, and no regulation of internal tribal affairs without a treaty by which the tribe agrees to federal regulation. Writing 50 years after the adoption of the Constitution, Chief Justice John Marshall drew a line in the sand. Conquest, he suggested, was an injustice that could not be undone. But that did not mean the Constitution allowed it to continue in the future. This policy is, in many respects, the current policy of the United States toward Indian nations. Since 1975, when Congress adopted the Indian Self-Determination and Education Assistance Act, it has been the general, although not completely consistent, policy of the United States to promote and respect tribal sovereignty and self-determination. Since that time, tribal governments have revived. They have rewritten their constitutions and tribal codes. They have drafted laws to protect the environment and natural resources. They've created or revitalized tribal courts and government agencies. They have embarked on tribal business enterprises. They've established tribal colleges. They've restored and taught tribal languages. And they have reinvigorated tribal cultural and religious practices. The Supreme Court has often held that tribal property rights and sovereignty are preserved unless Congress's intent to the contrary is clear and unambiguous. The Court has also held that Congress's power to legislate on Indian affairs is constitutional only if it is, quote, tied rationally to the fulfillment of Congress's unique obligations toward the Indians, unquote. Every president since Nixon has recognized or supported a government-to-government relationship between Indian nations and the United States. And every president since Bill Clinton has required consultation by the United States with Indian nations over matters that affect them. Every president, that is, except the current one. Perhaps he will get to this issue sometime in the future, perhaps not. The Constitution, as originally drafted, as interpreted by Chief Justice John Marshall, and as implemented by the first and the most recent Congresses and presidents, all point toward a constitutional system of cooperation, consultation, and mutual respect between Indian nations and the United States. The United States may well have interests that conflict with those of Indian nations, and it may sometimes act contrary to those interests. But the Constitution, as originally shaped and as recently construed, requires respect for the property and sovereignty of Indian nations, as well as a process of consultation and negotiation on matters that can affect tribal rights and interests. All of that may be a surprise to those Americans who have just lived through the Dakota Access Pipeline matter. That controversy seems to suggest the exact opposite of what I have just said. It suggests that the U.S. has the constitutional power to do whatever it likes with Indian nations, that it can pass laws that harm them, that it can do so without their consent, and that their concerns are taken less seriously than those of non-Indians. There is, unfortunately, a lot to this alternate view of the Constitution's treatment of Indian nations. Here are 5 pieces of bad news. First, The United States often ignored Chief Justice Marshall's injunction that Indian nations could not be forced to give up their lands. Forced removal was depressingly common. Second, the Supreme Court has held that Congress can regulate not only commerce with the Indian tribes, but the internal affairs of those tribes and even their own members. This is true despite the fact that those powers are not enumerated in Article 2 of the Constitution. According to the Supreme Court, Congress has plenary power over Indian nations. That means the states have no power to regulate Indians in Indian country without federal authorization. But it also means there are few, if any, limits on congressional power over Indian nations. While it is basic constitutional wisdom that Congress has only those powers enumerated in the text of the Constitution, that constitutional rule apparently does not apply to laws affecting Indian nations and tribal citizens. Although the Interstate Commerce Clause gives Congress the power to regulate commerce, but not other things, the Indian Commerce Clause has been interpreted to give Congress general police power to pass laws on any subject it likes, as long as the legislation regulates Indian nations or their citizens, even if the law has nothing whatsoever to do with commerce. When you learn about the Interstate Commerce Clause in your constitutional law classes, you might ask your professor about this, but they may or may not know about it. Indian law is not a topic usually covered at all in constitutional law casebooks, and so it's not covered in constitutional law classes, and in a lot of ways it's not the fault of the teachers not to know about this. Third, in 1903, the Supreme Court held that the United States can abrogate treaties with Indian nations unilaterally. Not only that, as I've explained, the U.S. can assert power over Indian nations without their consent. It's not the usual practice with treaties. If the United States repudiates a treaty with Mexico, we do not immediately treat Mexico as part of the U.S. Rather, we go our separate ways. Repudiating a treaty with a tribe usually is the opposite. Rather than a divorce, repudiation cements U.S. control over Indian nations and their people. Fourth, 1955, what I have to say is an outrageous decision. The Supreme Court held that tribal property can be seized by the U.S. government without compensation, unless Congress has chosen to formally recognize tribal property rights at some point in the past. In 1835, the Supreme Court held tribal property rights were as sacred as the fee simple of the whites. But in 1955, the Supreme Court said that tribal property was not property at all within the meaning of the Constitution. Finally, the Supreme Court has exercised its own common law powers in recent years to limit the ability of Indian nations to apply their laws to non-Indians who enter tribal territory. In these 5 ways, as well as others, the Constitution has been interpreted to authorize acts of conquest. The Constitution was established by we the people, and that means the source of legitimate government power is the consent of the governed. The United States has repeatedly and systematically violated that core democratic principle in its treatment of Indian nations. At the same time, as I have explained, federal law has repeatedly intervened to protect Indian nations and to recognize their sovereignty and property rights. It has done so at moments when federal officials and lawmakers have remembered our fundamental values. It's done so when we have remembered the reasons we adopted the Constitution of the United States of America. Where does that leave us? Does the U.S. Constitution respect tribal sovereignty, or does it authorize and justify the conquest of Indian nations? The answer was given by Chris Pratt's character Star-Lord at the end of the first Guardians of the Galaxy movie. A bit of both. The Constitution protects tribal sovereignty, but the Supreme Court has interpreted the Constitution to empower Congress to limit or even destroy tribal sovereignty. The United States has flipped 180 degrees several times over the course of its history. sometimes seizing tribal lands and limiting the powers of tribal governments, and sometimes protecting those lands and those governments. That's not equivocating. In my view, limiting tribal sovereignty or harming tribal property without tribal consent is an act of conquest. It's an act that cannot be deemed consistent with our democratic values. We have a choice about how to understand and live with our Constitution. And the right choice is to stop engaging in conquest. Conquest is an historical fact. We cannot undo it. But that does not mean we can do nothing. What, in fact, can we do? First, we can recognize that conquest was not complete. Tribal sovereignty remains alongside the sovereignty of the federal and state governments. Second, non-Indians can learn about tribal governments and the federal laws that recognize, respect, and protect tribal sovereignty. Third, the United States can choose to honor and respect those laws. We can recognize the reality of conquest, but we can also commit not to do it ourselves. For those who worry that two sovereigns cannot inhabit the same territory, I would just like to remind you that we live in the United States of America, currently in the state of Maine, as well as the United States. Overlapping sovereignty is something we know about. Indeed, it has been a major point of contention for our entire history. Yet we manage by debating the appropriate relations between the state and federal governments. We don't manage by ignoring the states or denying them any reserved powers. Indeed, those powers are enshrined in the 10th and 11th Amendments. We know about divided sovereignty. We simply need to extend that knowledge to Indian nations. We respect tribal sovereignty. We simply need to extend that respect to Indian nations. We can do that first and foremost by consulting with Indian nations over matters that concern them. We can stop pretending that we take no heed when the United States threatens tribal lands and tribal governments. We can start treating Indian nations as partners rather than as annoyances. We can honor our treaty commitments. We can be curious about what those mean to the nations to whom the United States made sacred promises. We can follow the lead of Chief Justice Marshall, who lamented the fact of conquest and counseled the United States not to do it anymore. The U.S. Constitution is a striking achievement in the history of humankind, but it has also been used to inflict outrageous injustice. We can honor the Constitution by acknowledging the ways it has been interpreted to inflict dishonor and injustice, and we can commit to promote justice, democracy, and the rule of law, the best values of the Constitution. Recognizing tribal sovereignty and consulting with the governments of Indian nations on issues that affect them is not just good policy. It is what the best interpretation of our Constitution asks of us.
And the question I have is kind of personal because when I first came to this country 17 years ago, I had a card which says alien residents. Then, although I was considered as an alien, I was required to register the selective service so I could be called upon to serve the United States during times of war. If you do live on a reservation, are you required to register with selective service? Because in World War II, they were considered to register, but because they live on a reservation, they have to register as miscellaneous county. Miscellaneous county is also used for people who are hospitalized and people who are institutionalized. Does that remain the same today?
A federal statute in 1924 made all American Indians citizens of the United States. So since 1924, all Indians have been U.S. citizens whether they wanted to be or not. A lot of people wanted to be, some people didn't want to be. So there's a whole history about this which is complicated. There were states up until the 1960s that did not allow Indians to vote in state elections. And the Supreme Court had to explain to people that violates the Equal Protection Clause. So I'm not an expert on rights of residents who are not citizens.
You said that the United States can unilaterally repudiate treaties.
The Supreme Court has said that.
Court has said that?
Yeah.
What, and so this is perhaps evidence of my ignorance of international law, but generally speaking, what is the remedy for a violation of a treaty?
This is what, again, I'm not an expert in international law, but what my international law colleagues tell me, if I'm wrong, people can. Normally, when you repudiate a treaty, that's like a breach of contract. The other side can choose to still comply with the treaty if they want to. Nothing says they have to, but it gives them the right to repudiate it also, and then you go away. You don't invade France. I mean, that requires a war and conquest, and usually but that's not what happens. When the treaties are repudiated, it's usually because there's a statute or a federal act that actually takes over tribal property or limits tribal sovereignty.
So Professor Singer, thank you so much for bringing this knowledge to our arena where we are sitting on land that is First Peoples property. So thank you for that. Thank you for paying tribute to them. The second statement or question I have relates to one of the items that you mentioned in the what can we do. So as I'm listing it and I'm saying yes because I'm on board, I then go back to number one because of my experience with Native Hawaiians. And the first what can we do is recognize conquest was incomplete. And I know exactly why you say recognize it because it was incomplete, but strategically, wouldn't that be admitting too much?
Well, what I mean by that is that acknowledging the facts that there are millions of non-Indians living in the territorial United States and that we're not going away, right? You can sort of imagine that can't be undone. And, you know, where I teach in Cambridge, students have asked me, who are the people that were there at the beginning? And there are probably still some descendants of those people, but at various points in time, several times in a row, 90% of the Massachusetts Indians died from disease. 90%, right? So just imagine that. And some descendants moved away and then joined the Nashpies in Cape Cod. And so the fact of coming here and a lot of deaths and displacement, when I say conquest happened, I mean just factually, you know, that happened. That's sort of what I'm referring to, and I think it doesn't do anyone good to pretend that history didn't happen. When I say it's incomplete, I'm emphasizing something that I didn't learn in law school. I was in a PhD program in political science. I didn't finish. I did everything but the dissertation. So I have a graduate degree in political science and a graduate degree in law. No one ever told me that there were tribal governments in the United States, and I didn't know. I just didn't know at all. I thought, didn't we the United States, conquer the Indians? And I was wrong. It is a matter of federal law, and it has been since the beginning, that the tribal governments persisted and were not obliterated. I just never learned about that. So the idea that the governments pre-exist the United States and never went away, and they coexist alongside state and federal governments, that's what I'm referring to about the conquest being incomplete. The conquest happening is you painful parts of the history can't be pushed aside. You have to recognize them. And then the question is, tribes want to coexist with the United States. Tribal citizens are also American citizens. Many died in wars defending the United States. And many Indians are very patriotic and love the United States. Having a good relationship is actually what treaties are about. Rob Williams, when he talks about how they are not as viewed treaties, he talks about a work of art that shows two canoes going down the river side by side. And the conception of contracts. When we teach contracts, we tend to try and figure out the magic moment when there was no obligation, and then there's an obligation, and then the obligation is fixed at that moment. And my understanding is historically, and I think also currently, that tribes conceptualize treaties more as a marriage or friendship, which is a relation that continues over time. And you negotiate change in a relationship over time. It's not that the obligations are fixed at the beginning, but there's an idea of consultation. And it's a long-term contract rather than a transactional contract. So you can recognize that there are two sovereigns working together rather than one of them just enslaving the other one.
What hypothetically would be the impact of some or all of the 537 tribes saying we're going to merge and have one far greater territory, far greater population than currently each of the fairly small, unto themselves sovereigns have?
Well, that's kind of a science fiction question, because for one thing, that's sort of like, what if all the countries in Europe merged, which they could, but they haven't. You know, the tribes are not going to. There is something called the National Congress of American Indians, where they get together and have an organization that tries to talk about what they want the law to be and promote their interests. But you know, the tribes they're as different as France and Germany, and so that's not going to happen. If they did merge, they could do that if they wanted to under their own law.
And under the Constitution?
Under their own law, they could do whatever they want.
Yeah.
They would then, if they wanted that to alter the relationship with the United States, they'd have to work it out with the United States, and the United States would do whatever it would do in relation to that. And I have no idea what the United States would do. You know, it's sort of, I mean, I haven't thought that through, because it's not something that's realistic.
You mentioned that there were a couple of groups, specifically in northern Maine, that aren't recognized, and my very rudimentary understanding is that has something to do with their recognition by the Canadian government. I was wondering if you can maybe
That by
elaborate.
itself wouldn't mean that couldn't be recognized by the U.S. There's a U.S. law in the 20th century. If you go back, the United States just went out and decided who they'd recognize. They kind of just made treaties with groups of people and had names for them. And sometimes the groups were actual groups. Sometimes there were subgroups. Sometimes there were several pushed together. So the U.S. made decisions that sometimes conflicted with what the tribes thought. At the end of the 19th century, when the United States was trying to break up tribal government and control it, they created roles because they wanted a list of tribal members. That was a federal administrative process. And that process left a lot of tribal members off the rolls. But the U.S. needed to be able to hand out money and divide up property, and so they needed some list. So they created, and then there were some tribes trying to get recognized by the United States in order to get some federal benefits and also to exercise self-determination. There were some tribes that tried to get recognition in the courts. The Mashpee Wampanoags in Massachusetts did that, and it didn't work out for them. And Congress would recognize tribes by passing statutes. The process was somewhat disorganized. There wasn't any standards for it, and Congress finally passed a law authorizing the Bureau of Indian Affairs to to have an administrative process to recognize tribes. Congress still could pass a law recognizing a tribe, but they generally leave it to the BIA process. And that process has gotten better over recent years, but still it takes a long time to get recognized. There are criteria that the U.S. has adopted that are not the same as the criteria the tribes adopt. The U.S. wants proof, some of which is impossible to get if you don't have written records. So there's the proof process that is gone through is one that's difficult for some tribes, and some of them that deserve federal recognition may never get it because they may not have the proof that's required by the U.S. to be recognized.
The last question. Oh, okay. So currently in the state of Maine, there's some conflict about surface water usage rights between one of the tribes and the United States government. And I know that and I know that the EPA and the Maine Department of Environmental Protection have been kind of not seeing eye to eye about all of the specifics. Thinking about overlapping sovereignty, what role does a sovereign state, United States state, play in the relationship between the congressional power with Indian tribes and when there's a tribe within the state's territory?
Take a course in federal Indian law. It's a whole chapter about that. It's quite complicated. Here's the shortest answer I can give you. The Articles of Confederation that we had before the Constitution, they couldn't work out who was going to have power, the states or the federal government. So they wrote something completely incoherent and funny. They said the U.S. has sole authority to regulate in Indian affairs, except for Indians who are members of the states. And the U.S. law should not interfere with the legislative jurisdiction of the states. James Madison in the 42nd Federalist paper makes fun of this. He says, how you can give 100% of the power to someone and have some left for someone else? It's a mathematical impossibility. The Constitution got rid of the state powers. The Indian Commerce Clause gives the federal government the sole authority to regulate Indian nations. That's the holding of Worcester versus Georgia in 1832. But later Supreme Courts have said states have some powers in the Indian territory. Maine is a completely different animal. Because like Massachusetts, there were no treaties here. Because people died. It was the beginning. These were the first victims of conquest. People died, new tribes were formed, people had to move away. There were no treaties. From my standpoint that I've given you, that means there's no legitimate authority the United States has over the tribes in New England. Because there's no voluntary agreement. Statutes were passed by Congress settling land claims. There was some negotiation there. There were some of the tribes in New England that were happy with the land claim statutes, but many of them were not happy with it. Those statutes were imposed on them against their will, right? Those statutes authorize state jurisdiction in Indian country in certain ways, in a way that's very different from the rest of the country. And it's actually, to me, fundamentally unfair to have the tribes in Massachusetts and Maine have such fundamentally different powers than tribes do elsewhere. Now that we have gone back to the policy of promoting tribal sovereignty, it would be better if actually the situation in New England were brought up to the standards that other tribes have. But there are some powers that states have in Indian country because the Congress has created some, and the Supreme Court has authorized some, and so it's actually a very complicated area of what powers the states have versus tribes. It's actually quite complicated. One thing I will say is that despite its complication, in general, Indian nations have almost complete power over their own citizens within their own territory on their own land. So there's been very little limitation on tribal sovereignty over their own citizens, at least in their own territory. So that's pretty capacious. The limits have normally been jurisdiction over non-Indians. And then sometimes decisions like the recent First Circuit decision that says when the Penobscots were given islands, they have no rights in the water. Even though any other property right any other property owner in New England, any New England state, if they have rights in land, they have rights, if their land is on water, they have rights in the water also. So the fact that you're given an island doesn't mean you have no water rights, I guess, unless you were an observance. So.
Professor Singer, on behalf of the University of Maine School of Law, I am very pleased to award you this gift, but having driven you here from the hotel and seeing the bags you have, I feel really bad about it. Here's another bag. Thank you.